Hi, I'm Akhil Reed Amar, and I'm a professor at Yale Law School. I think the text of the Constitution itself, at various key places, signals its awareness of the need to go beyond the text in order to complete the text. I think the most dramatic illustration is the Ninth Amendment, which says that the listing, the enumeration of certain rights in the text should not be construed to, quote, deny or disparage, unquote, other rights retained by the people. So the mere fact that a right doesn't exist in a textually listed way is not a sufficient reason for dismissing such a right. But unfortunately, the Ninth Amendment doesn't. So apparently there are rights that aren't textual. Okay, that's great. But the Ninth Amendment doesn't carefully tell us where to find all those rights, but I think it gives us some hints. It says these are rights of the people. And so one idea is, let's look to what the people themselves think and say and do to find the rights that the people themselves believe they have. Ordinary people living out their lives in ordinary ways embody a multitude of rights. This is a kind of Burkean thought, that the Constitution doesn't in so many words say you have a right to wear a hat or play the fiddle or raise your kids or have a pet dog. But this is America. Of course you have those rights and lots more. Now that actually suggests a way of cashing out the Ninth Amendment. And it has counterpart language in the 14th Amendment that says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. The Ninth Amendment was about the federal government, but then the 14th Amendment, after the Civil War, comes along and says, we don't want states messing around with fundamental rights either, with what it calls the privileges and immunities of citizens of the United States, fundamental rights. Only one problem. It doesn't list what those privileges or immunities are. It says states can't mess with them, but it doesn't comprehensively list them. The Ninth Amendment says the feds can't mess with unenumerated rights, but it doesn't comprehensively list them. But I think there are clues. These are rights of the people. These are privileges and immunities of citizens. So here's what judges should do. Among other things, they should look to the citizens themselves to see what rights the citizens believe they have and embody in their daily practices. They should look to the people themselves. One way they can do that is just simply by counting, taking account of and taking a count of ordinary popular practices. So, for example, the famous 1965 case of Griswold versus Connecticut involved a law that made it a crime for couples, even married couples, in the privacy of their own home, even in the privacy of their own home, to use contraception. So Connecticut actually had made it a crime for even married couples to use contraception, to use it, even in the privacy of their own home. And the Supreme Court invalidated that, and in one of the opinions, Justice Harlan, in effect, says, this is un-American. No other state has ever done anything like that in American history. He basically counted practices and in a kind of Burkean traditionalist way looked out at America and said, this is a law that really doesn't fit our traditions, our customs. That's one way. It's not the only way of giving meaning to the Ninth Amendment and the 14th Amendment's privileges or immunities clause, but it's one way, an important way. So let's talk about different kinds of rights and different techniques for finding them. And some of the rights are ancient and traditional, and some of the rights are new. One idea is a right is textually enumerated, but the text may be somewhat ambiguous. There is a textually enumerated right to equality. And it doesn't just say racial equality. It says equality more generally. Equal protection is to be enjoyed by all persons. And the first sentence of the 14th Amendment says, in effect, that everyone who's born in America is born a citizen. They're, in effect, born an equal citizen. We are all, in effect, born equal. We're all created equal, to borrow a phrase. And that idea isn't just limited to race. Yes, we are born equal black and white, but we also are born equal male and female. We're born equal, they're born first in the family or third, so the firstborn shouldn't get more legal inheritance rights, whether we're born in wedlock or out of wedlock. So there shouldn't be discrimination against so-called illegitimate children, whether we're born gay or straight, if there's a biological substratum to sexual orientation, whether we're born Jew or Gentile. So there's an idea of birth equality, and the text signals that, but it doesn't fully flesh out the idea. And let's take segregation. Is segregation equal? Well, it might matter what ordinary people think. And the answer is segregation can be equal, but isn't always equal. Let's take sex segregation. We segregate high school gym classes and bathrooms and locker rooms and shower rooms by sex, and that's generally not seen as unequal today. And one reason it's not is that I would say both women and men generally perceive this kind of segregation as equal, separate but equal. Both of them do. And if either sex perceived it as unequal, that would be a good reason for judges to pay close attention to this. Now, when it comes to race, separate bathrooms or other facilities that were race segregated have been understood in America as unequal. And even if most whites thought they were equal, it would still matter what blacks thought. Okay, so for some rights, maybe we don't care as much what the minority thinks, but for equality rights, I think we do, because equality is all about how both sides are treated along a legal line, whether the line is race or sex, or whether you make more than $250,000 a year, that's a legal line, or whether you are a wage earner or get your income from dividends and rent. The law is full of all sorts of lines of distinctions, and it might matter what people on both sides of the line thought, women as well as men, blacks as well as whites. So we have to look at what the text says, what word it uses, and then pay attention to how that word should, how that word plays out in the world beyond the text. If it uses words like the 9th and the 14th Amendment Privileges and Immunities Clause, they're saying they're unenumerated rights, so there's not that much text. Just what rights do ordinary people think they have? That may be more of a majoritarian test. If it uses a word like equal, well, that's a textually enumerated right, and it's supposed to be equal, but we might pay attention to what blacks as well as whites, women as well as men think. If it uses a word like reasonable, the 4th Amendment says there should be no unreasonable searches or seizures, well, that might be, again, more of a majoritarian test. What do most people think is reasonable? Or you could say, no, actually reasonableness incorporates ideas of equality and other things, so we do have to pay attention to what both sides think. How about a phrase like no cruel or unusual punishment? That seems relatively majoritarian. What practices are usual and what practices are unusual? So there was a time in America when putting juvenile offenders to death was common, customary, traditional, widespread, not unusual. And then American practices changed, and at a certain point, actually, only a few states were left that have the death penalty for juvenile offenders. At a certain point, the death penalty for juvenile offenders became unusual. Let's take the right of a criminal defendant to testify on his own behalf. The text doesn't say that he has that right. It's just not mentioned in the Constitution. At the time the Constitution was adopted, no criminal defendant had such a right. But practices changed. States beginning in the 1850s began to recognize such a right. By 1900, almost all states actually did allow a criminal defendant to testify, and at a certain point, it became a basic unenumerated right of the people just because it had swept the land, because ordinary people thought they had this right, were exercising it in courtrooms every day across the country, state courtrooms as well as federal courtrooms. So I've given you, just in the last few minutes, just a whole range of different examples of enumerated and unenumerated rights, and how you might want to ask slightly different questions for each right. Is it unusual in the Eighth Amendment context? Is it reasonable in the Fourth Amendment context? Is it equal in the context of the 14th Amendment equal protection and equal citizenship provisions? Or more generally, for unenumerated rights, where there isn't a word like reasonable, equal, unusual that we're focused on, in the case of just general unenumerated rights, is this the sort of thing that ordinary Americans believe themselves to, is this the kind of right that ordinary Americans believe themselves to have and actually do exercise in their daily lives in most places in America? Gay marriage is a really interesting case study. Here's I think the prediction. There will be a constitutional right to gay marriage very soon, within the next 10 years, I would predict, because within the next 10 years, gay marriage will sweep the land. More than half the states, representing more than half of Americans, will actually recognize gay marriage, and even if they don't recognize gay marriage solemnized in their own state, they will recognize out-of-state gay marriages. So even if Wyoming doesn't recognize gay marriage, it might say, yeah, but if you go to Nevada, you go to New York and get married, we'll recognize that when you come back to Wyoming. When that happens, the Supreme Court, I predict, will say this has now become an unenumerated right. And that's going to happen within the next 10 years. It's possible to imagine a court saying, let's not wait 10 years. So actually the most cautious justice will not, the most cautious court, will probably not wait more than 10 years. A more forward-leaning court might say, the Constitution says equal. This isn't really equal. There's now, actually, maybe straights don't fully understand that it's not equal, but gays understand that it's not equal. And when it comes to equality, we want to look at both sides of a legal distinction. Gays aren't allowed to marry. Straights are. How do gays think about it? In the same way that when it came to apartheid, the Brown versus Board of Education court wasn't interested just in whether whites thought it was equal. Maybe some of them in good faith did think that segregation was equal, but it also looked at whether blacks thought it was equal. And by 1954, let me tell you, most blacks and black leaders were making clear that they did not think that racial apartheid was really equal. And when it comes to a word like equal, we have to look at both sides of the equation. And gay marriage is particularly interesting because I think one big idea is the equality idea. It's a little complicated because the equality idea is most strong when it comes to the law distinguishing people on the basis of distinguishing on the basis of their birth status, treating them differently and maybe unfairly or harshly, with disfavor at least, because of how they were born. And people are born black or white, in our social understanding. They're born male or female. The science is not completely clear. It might be contested about whether one is born gay or straight. It might be, and actually it might be a complex combination of genetic factors, early developmental factors, and choice.